Hey guys, it's Anthony Bandiero here, attorney and senior legal instructor for Blue to Gold Law Enforcement Training, bringing you another Roadside Chat from Knoxville, Tennessee. Okay, so I'm at the airport. That's why I'm not all dressed up. I'm going to be traveling today. So here's actually a very good question. The question essentially is this: can we use a vehicle inventory search as a pretext to search for criminal evidence? Okay, so I definitely have your answer. Let me just kind of give you some context here. An officer from Illinois says that basically they pull over a car. The driver has no license, suspended, revoked, whatever. They have the option to tow that car under their policy, under state law. Very common. I mean, that's a very common scenario and option for cops. But there's a little bit of a twist here, because what they're doing sometimes is they will start the inventory process, right? And then if they don't find evidence, they'll basically change their mind and release the car to somebody else that they can, so the driver's still not driving, but ultimately, if no evidence is found, the car is not towed. Is that legal? Absolutely, 100% no. Here's why. So our seminal case on this issue is South Dakota versus Opperman. And the Supreme Court said that, a vehicle inventory is essentially a community caretaking function. When cops are inventorying cars, they're trying to help the person and themselves, right? They're trying to help people. It's not for criminal investigations. They're trying to help the person to make sure that they know that, if anything gets lost or stolen, while the car's in the possession of the tow company, they have some recourse. It's also to protect the police department from false claims of damage, lost or stolen property, and so forth. So we require a good motive here, right? Now, the problem is that if we get the cop on the stand and we say, okay, if you did not find evidence, would you have let the car go? And if the cop says, well, yeah, we would have ultimately not towed the car. That was, kind of a routine here. We start the inventory process, and if we don't find anything, we let the car go. But if we find something, then we ultimately tow the car. We make an arrest, we add charges and so forth. And that's just a bad motive. If the court knew what the cops were up to, there's no way, in my opinion, they're going to uphold that, because it's the inventory exception cannot be used to short circuit the probable cause requirement, right? So, and because inventory searches don't require probable cause, they just require, just this motive to protect the driver and the department from, and so forth. If that's all it takes, then you just short circuit the Fourth Amendment. You don't need a warrant. You don't need probable cause. All you need is just have to have a reason to tow the car, and so forth. So, look, as far as towing the car, if the cops are going to tow the car, just tow the car, right? And finish your inventory sheet, and and most courts are going to uphold that under objective reasonableness. At the same time, though, I have to, just kind of share with everybody that we don't need any more bad case law, in law enforcement. We already have our fair share. Every bad case has a name on it. And if the courts really knew that, the car was getting towed with the primary purpose to find evidence, and the primary purpose was not to safeguard property, protect it from vandalism, it's, get it out of the roadway because it's blocking traffic, and so forth. If they really knew what the cops were up to, they would not be happy. And they're going to hammer, and they're going to, the cops, and they're going to make more restrictions. So let's not do it. Tow the cars for a lawful, valid purpose, and have the primary motive to be community caretaking. Don't have the primary motive to be looking for evidence, and that's your way into the car. At the same time, do not get me wrong. if you have no choice but to tow that car because the law requires it, it's your policy requires it, it's blocking traffic and all this stuff, then we don't really care what your motive is, because at the end of the day, the result is the same. The car is going to be towed and stuff is going to be inventoried. Okay? But that's my advice to you. It's a very good question. In fact, I do go into depth on this issue in my advanced traffic stops class. And I am trying to help cops, make good law, because the reality is that, inventory searches have been used as a pretext to get into cars. However, that motive is not condoned by the U.S. Supreme Court. All right? All right. So there's my answer. I hope you appreciate where I'm coming from on this, and you understand. Again, we're not trying to make bad case law. We're trying to make good case law, and so forth. All right? So if you want me to keep continue making these videos, I'm gonna ask you 3 things. 1, hit the like button or comment below. 2, subscribe, right? And number 3, share this with your friends. Share the channel with your friends. I'm trying to get, tens and tens of thousands of cops watching these, because I think they help. And if they do help, then share it. All right? Until next time, my friends, stay safe.
When it comes to law enforcement training, we are the gold standard. Visit bluetogold.com or call 888-579-7796 to learn more about our training, books, and free webinars. Also, don't forget to like, subscribe, and share this channel.